And I understand, and I would argue to the court, that when you have a young child who is developmentally delayed, who is deaf, who is brought into a confrontational courtroom with a ton of people and put on a witness stand, and then ask a variety of questions, regardless of how you ask those questions, that can be intimidating, confusing, scary, and she may not have reacted the way that you or I would expect any other witness to react. Does that impugn her ability to understand telling the truth? And my argument, Your Honor, is no, it does not. And I would further argue, in opposite to Mr. Vanderhagen, that in my experience in dealing with developmentally delayed people, they don't know how to lie.
Oh, that is just Poppy. And I am objecting to that. If this is where this is going, you had a specific question you were asked him, and the state artfully ducked it. So now we're clear from that all the way over to the developmentally disabled. Don't lie. Poppycock.
I didn't say they don't lie. That they don't know how to lie.
Okay,
and that is a
what's the
huge difference.
I object to that. I mean, boy, we're splitting hairs here. How many angels can dance on the head of a pin?
All right. Gentlemen, there's no valid objection to another lawyer's legal argument in a non-jury hearing. He's talking about his experience with the developmentally disabled, and he's free to stand at the podium and say it. And I know he's not an expert, and I don't think he's an expert.
Because I respect this. About inappropriate argument. And that's all.
All right.
Well, Your Honor, with all due respect,
Hang on.
thank you.
So I've noted your poppycock objection. I'm not sure.
Put it nicer language.
I'm not sure which rule of evidence is the poppycock rule, but you've put your objection on the record. I don't know if it's poppycock or not.
There's no basis in evidence, so therefore the argument is not relevant. And it's not appropriate, meaning I can come up with a whole bunch of them. So it's similar to inappropriate arguments in opening or closing. This is an argument about a matter of he's saying, well, why he gets to have a evaluation, and he is misstating facts to the court. I don't care if it's based on his experience or not. He is misstating facts to the court that go to this and are central to the court's ruling. And therefore, I don't think he gets to make that argument.
Well, I don't think yeah, there's a lot to unpack here. He's standing at the podium talking about his experience with disabled people.
I'll withdraw the objection.
No. Look, I want you to understand what the deal here is. He's standing at the podium in a non-jury hearing, making an argument about what he thinks I should do. And he's making representations about his experience with this disabled people. He's not sworn to tell the truth. He is not an expert witness. He has, as near as I can tell, very little to no foundation to make factual representations about whether developmentally disabled people are more or less likely to lie than anyone else. And so I think the correct procedure for me is to listen respectfully and then not give it very much weight, which is what I intend to do.